Generally, a life tenant may be liable for waste if the tenant substantially and permanently damages the property or fails to make necessary repairs to prevent the property from deteriorating. But what if a life tenant fails to pay taxes on the property? Could this constitute waste? The Massachusetts Court of Appeals considered this question in Matteson v. Walsh. In 1977, Dorothy Walsh devised a life estate in property she owned in Chatham, Massachusetts, to her son Robert Walsh by will. Further, Dorothy devised the remainder to Robert's heirs and her other children, Elizabeth Matteson and Catherine Baisly. 10 years later, Dorothy died. Walsh lived on the property, but in 2004 he stopped paying taxes and allowed the property to fall into disrepair. Chatham then instituted a tax taking. After learning of the taking, Matteson and Bailey paid the debt off and Walsh reimbursed them. Over the next 3 years, Walsh again failed to pay the taxes, and Matteson paid those debts. But Walsh didn't reimburse Matteson. Matteson also hired a repairman. Walsh didn't object, but didn't reimburse Matteson for the amount she paid. Subsequently, Matteson sued Walsh in state superior court for waste based on Walsh's failure to pay taxes and make ordinary repairs necessary to prevent the property from deteriorating. Following a bench trial, the judge found for Matteson and awarded her money for property taxes and repair costs. The judge then terminated Walsh's life estate and granted title in the property to Matteson, Walsh, and Baisly as tenants in common. Walsh appealed the decision to the Massachusetts Court of Appeals, and Matteson cross-appealed based on the decision to grant Walsh a fee interest in common in the property.